Rob Clementi from Television Education Network, and I'm with Adam Cooper from Cooper Family Law in Brisbane. Adam's presenting a paper at our July Family Law Conference on the Gold Coast on the subject of family violence and property settlements. Adam joins me today to provide a sneak peek into the subjects he's going to be covering in his paper. Adam, welcome and thank you for joining us. Why are Kenan claims so rare, and what can be done to improve the lot of victims bringing these claims?
Well, thanks very much, Rob, and certainly looking forward to the conference in July. There's some wonderful papers available. There are a number of what I might call policy or jurisprudential issues that the court has to grapple with when dealing with the issue of family violence claims in property proceedings, or Kenan claims as I call them, from the 1997 case of Kenan and Kenan. Some of these policy considerations, firstly, are the general rubric of the no-fault divorce, and that generally speaking, the court is obliged not to ascribe fault in making determinations either in parenting or property matters. The second issue is what might be called the floodgates argument, a policy consideration best known to our friends in tort law regarding negligence, but the idea that we would open up negative type behaviours that might have financial consequences and that there might not be any limitation to such a claim. And the third is the general concept of the negative contribution, which the court has eschewed over a number of years, not the least of which it has a number of significant ramifications in the determination of the comparative contribution. So they're the policy considerations which detract from what might be called Kenan claims. On the other side of the ledger is the reality that family violence has a financial impact on victims and families. It has a significant impact on a party's capacity to make contributions in the first place. And it also has a significant impact on that party's future needs that might be considered under Section 75(2) or 90 SF of the Family Law Act. So we have these competing jurisprudential issues, and for the best part, the court has tried to strike a balance, in my view, within those competing policy considerations. For that reason, what often happens is that the evidence needed to bring a Kenan claim successfully is usually quite difficult, and the adjustment that parties ultimately get when successful is fairly modest. And so the reality is often lawyers will say to their clients, look, it's not worth the ticket, certainly not worth the emotional expense of bringing such a claim when the outcome is unlikely to achieve much. And then whether or not a party is successful on such a claim, it's certainly not worth then appealing. And so the full court very rarely hears about these matters and has, as a result, not often been able to adjust or to develop the jurisprudence regarding these claims since 1997. But the reality is that these claims need to be brought, and in circumstances where the family violence has had a direct impact on a party's capacity to contribute, then in my view, it ought to be brought. And in those circumstances, whilst the court is not a vehicle for social engineering, it is really the only way that that financial justice to victims can be applied.
Adam, that was a very interesting insight into the paper you're going to be presenting. We're very much looking forward to hearing it when you speak for us in July. For those of you who've been listening, I hope you've enjoyed this presentation. And if you'd like to know more about the conference, just go to our website, click on the banner for the conference. You'll be able to download a brochure and register online. In the meantime, thank you so much for listening.